Hello and welcome. You are listening to an informed take on current events brought to you by law students and staff of Queen's University Belfast. This is Law Pod.
Hello and welcome to the new mini-series with Law Pod titled Speaking Her Truth. We are a group of 4 young, strong women from all over the world studying law because of our passion for social justice. We speak from primarily a female's perspective on various injustices while still touching on how men and other minorities are affected and the ways that the law can protect you or may not have protection currently in place. My name is Alexandra Cook and I am a first-year senior status law student from Canada.
My name is Tavisha Sood and I'm one of the 4 members of LawPod's group Speaking Her Truth. I moved to Belfast 6 years ago from India and I'm currently a first-year law student at Queen's University Belfast.
My name is Jade Mc Cauley. I'm from a small village in County Donegal. I'm a second-year Law with Politics student. I joined the Law Pod to shine a light and create awareness on issues that I'm passionate about. I also joined to make topical issues more accessible to students.
Hello, I am Maeve Devlin, a second-year Law with Politics student here at Queen's University Belfast. I'm originally from Chicago, Illinois, but have moved to Belfast to pursue a bachelor's degree. I decided to join the Law Pod due to my overwhelming compassion for human rights and social justice, and thought the Law Pod would be an excellent way to spread awareness to legal injustices.
Today's episode, we will be talking about rape myths. We are very fortunate to have a special guest join us today, Rosie Cowen. Now she'll introduce herself.
Hi there. Thank you for having me. My name is Rosie Cowen and I'm a first-year PhD student and I'm looking at jury decision-making in rape trials.
So to start our episode, we would just like to weigh in with Rosie about defining rape myths.
Well, rape myths have been around for centuries. Basically, they come from the patriarchal system and they are false assumptions about sex and sexuality and rape victims, which basically, if you deviate from these unwritten rules about sex, then rape myths are around to blame the victim and excuse the perpetrator. And they apply not just to women victims, but to people of all genders and sexualities and races, but they basically stem from the patriarchal beliefs and values. So most rape cases which actually end up in court hinge on the issue of consent. Whether the victim in fact consented to sexual intercourse, with the defendant usually claiming that she did. So a lot of rape myths are around that, around consent, which of course has different definitions in the law in different parts of the world.
So in the Sexual Offences Northern Ireland Order 2008, consent is defined under Section 3 as, for the purposes of this order, a person consents if he agrees by choice and has the freedom and capacity to make that choice. Now, that is the only definition of consent that is listed in this order. In order to contrast in different jurisdictions, especially where the 4 of us are from, we would just like to contrast from a Canadian perspective on my point, what the differences are in statutes. So under the Canadian Criminal Code, Section 153.1, subsection 22, consent is defined as the voluntary agreement of the complainants to engage in the sexual activity in question. Now, what's interesting to contrast this against the Northern Ireland Order of Sexual Offences is that the Canadian Criminal Code actually goes on to describe when no consent is obtained and what that looks like. This is defined under Section 3A to E. So Section A states, agreement is expressed by words or conduct of a person other than the complainant. A.1 says the complainant is unconscious. Section B, the complainant is incapable of consenting to the activity for any reason other than one referred to in paragraph A. Section C, the accused counsels or incites the complainant to engage in the activity by abusing a position of trust, power, or authority. Section D, the complainant expresses by words or conduct a lack of agreement to engage in the activity. And Section E, the complainant, arguably, I think this is a pretty important one, having consented to engage in sexual activity, expresses by words or conduct a lack of agreement to continue to engage in the act.
I think that's a really important one when it comes to consent, the idea, because people often think that if consent is given at the start, that consent carries throughout. But I think it's really important for people to know that consent needs to be given throughout for each different sexual act, not that you want to do, because then, you know, it's well within your rights to not want to do certain things, but be okay with the rest. So I think that's a really important section. When it comes to India, Section 375 of the Indian Penal Code defines consent as an unequivocal voluntary agreement when the woman, by words, gestures, or any form of verbal or non-verbal communication, communicates willingness to participate in the specific sexual act. But what's really important is there was actually a case in 2017, which was Mahmood Faruqi versus the state of NCT of Delhi, that actually undermined the purpose of this act that was introduced in 2013 and actually garnered a lot of public outcry when it came to that. So in contrast again to the Northern Ireland order, I think it's a lot more descriptive and there's a lot more present there for interpretation.
In California, consent is defined to mean positive cooperation in act or attitude pursuant to exercise of free will. The person must act freely and voluntarily and have knowledge of the nature of the act or transaction involved. In California, the consent statute stands out in comparison to the rest of the United States due to this common misconception that consent is purely a verbal exchange between individuals rather than obtaining a visual component referring to the attitude of the individuals involved.
Consent in the Republic of Ireland is found under the Criminal Law Sexual Offences Act 2017. It states that a person consents to a sexual act if he or she freely and voluntarily agrees to engage in that act. The act also provides several circumstances under which consent cannot be given. A person does not give consent if he or she is asleep or unconscious, for example. And similarly to Canada, the act also states that consent can be withdrawn at any time before or while the act is taking place, and this is in stark contrast to Northern Ireland's act.
Yeah, I think the main reason why we just kind of talked about consent and kind of did that was because I think a lot of rape myths indicate the presence of consent when they really don't. So, for example, one of the common ones that I've always heard is, it was provoked because of the way she dressed. So, as if her wearing a skirt or her wearing whatever she's wearing is in any way saying yes to be raped. And so I think rape myths kind of put forward this idea that if you do this or you do that or you say this, then that's just unequivocal consent given right then and there, which is why I think it was really important for us to talk about that.
I think it's really interesting to look at the different definitions of consent legally around the world, and it is a very disputed issue. There's a big debate in the legal world at the minute about in the UK about moving towards a more positive affirmation of consent, defining it a bit more. In the law in Northern Ireland and in England and Wales as well, there's also a clause about the defendant's reasonable belief in consent, which can cause a lot of problems too when maybe a situation where there's been, alcohol taken. What is belief in consent and what is reasonable belief, so that can leave the door open for a lot of rape myths as well.
For sure, because I think that is sort of putting more power into the defendant's hands of being able to say, well, I thought this or I thought that, and then that sort of leaves the defendant's word against the victim, which, in comparison to reflecting on that the Californian statute, where the attitude itself is acknowledged in the statute, I think is pretty huge. Just imagine if everywhere had a statute like that, what what repercussions that could be like for victims of sexual offences.
Well, of course, in any criminal trial here, the burden of proof is on the prosecution, but often in a rape case, the consequences of that, it does become a he said, she said contest of credibility between the complainant and the defendant. One of the difficulties, I suppose, with that, more trying to flesh out and define consent and a positive definition of consent, is it really realistic? How can we be sure by verbal or non-verbal indications that the complainant did consent to this action, to that action? And you're absolutely right. A very important thing about consent is it's continuing, it's ongoing. Lady Hale, or the outgoing President of the Supreme Court of the UK, said that consent is very particular. It's to a particular person, to a particular act, at a particular time.
About drinking and how drugs and alcohol can always sort of cast a reasonable doubt on, I thought that consent was there and stuff. But in my head, it's, if drinking or drugs or dressing a certain way provokes rape, then anybody who's not doing that shouldn't technically be ever raped. Like, if people put forward this argument that, like drinking leads to rape, then no one who's sober should have ever been raped. And that's where I think these myths start to fall apart. And I think it's important that people my age and even younger are made aware of these, because you never really think about them unless you're told about them. And once you start to think about them and you start to pick them apart, you really see that they really are detrimental when it comes to rape victims.
And there are deep psychological reasons why people believe rape myths, as well as being in this culture and society which is patriarchal. There's a great comfort in thinking, even though it's not true, that if we keep the rules, if we dress a certain way, if we don't drink too much, if we don't take drugs, that nothing bad will ever happen to us. And that indeed is one of the reasons that rape myths run very deep psychologically.
Mm-hmm. Do you also think the whole stigma around rape kind of gives power to these rape myths?
Yes, and many victims believe rape myths too. It's very important. It's one of the reasons that so few people come forward to report rape to the police, is that many victims don't define maybe until years later what happened to them as rape, or they're ashamed, misplaced guilt. So sure, they affect everyone, even the victims and the perpetrators, and everyone within the criminal justice system.
Bringing it back here home to Northern Ireland, when you have a high-profile case where someone does come forward with allegations, specifically referring to the Paddy Jackson case, Rosie, as a researcher studying that case, what can you speak to in terms of what you saw in the courtroom referring back to rape myths?
Well, as you said, Alex, this was a very high-profile case. 2 members of the Ulster rugby team charged with rape, and 2 of their friends charged with lesser offences. It garnered a great deal of media coverage and a great deal of controversy. It's important to say that all 4 men were acquitted of all charges, but I did attend a great deal of that trial and saw a lot of rape myths brought forward by the defence team in court, which I have to say is, in my previous life as a journalist covering other cases, this is pretty much standard practice. It was said that the young woman was kind of a groupie, a fan, and that she went home to Paddy Jackson's house because she was starstruck, and she complained, called rape the next day because she was ashamed of what she'd done, that she didn't call for help when someone else entered the room, one of the other girls at the party, and that she didn't fight off. And these were all used in court by the defence team to suggest that she wasn't raped. As I said, all 4 men were acquitted of all charges, and because we're not privy to jury deliberations, we can't draw a line and say that this was why or how the jury made their decision. That's something that we don't know. But the case did create great controversy with people on both sides of the debate. So as it brought to the fore, one of the points was the kind of use of rape myths, and also the production of the complainant's underwear in court, which is also quite a common thing in a rape case, for the complainant's underwear to be passed around the jury and displayed.
There was a case down south about that garnered a massive public outcry. I remember where the woman, I think, was wearing a thong, and that was passed around the court as a way to be like, oh look, she consented, which kind of again brings us back to that rape myth of the way you dress, you're asking for it almost.
Yeah, I mean, it's rare that underwear, as I said, most rape trials are about consent. It's rare that underwear has any kind of forensic evidential value in a rape case. So often the reasons for this, I think, are a tactic by the defence team, really, to humiliate the complainant.
Yeah, I think it sexualises something so ordinary as underwear, something that everyone and anyone wears, just as a way to sort of, I think, victim shame almost.
Yep, and you may remember some of the protests that took place after the Belfast Ulster Rugby trial, women indeed wearing underwear over their clothes and saying this is not an invitation to rape me. So that point was certainly highlighted during that trial, and the one down in Cork as well that you mentioned with the thong.
Referring back to what you said earlier, Rosie, that a rape myth is that a complainant should scream out and fight, but of course we know that it's very often that victims or complainants freeze as a response to this act.
Yes, definitely. I actually saw this displayed many times while interning at the Illinois State's Attorney's Office watching sexual offense cases, that I actually was drawn to look up if there is scientific research behind this freezing sensation. And there has in recent years been articles addressing this tonic immobility experience that is similar to an animal's like fight or flight kind of sensation. And a quote from an article addressing tonic immobility says, "Rape victims who present tonic immobility during the sexual assault are frequently overwhelmed by shame and can receive less empathy as well as less legal protection because successful prosecution of sexual offenders in legal courts is strongly related to the signs of resistance in most countries." While in the statutes in Northern Ireland do not say that you have to fight back, this is commonly an argument brought on by the defence to discredit the survivor.
Yeah, and I think oftentimes the victim or the complainant would often even freeze just as a way to protect themselves out of fear of violence if they did fight back. Like the case I mentioned earlier that kind of undermined India's consent. In the Indian Penal Code, the Mahmood Faruqi, one of the arguments made against the complainant or the victim was that, she didn't fight back, that she just like laid there and there was no like physical fighting back. And so in some twisted way, that was her way of saying yes. But I think a lot of the times that can stem from, fear of actually escalating and even fear of death or being killed.
I think a lot of this comes from this image of real rape as a madman stranger jumping on a woman in a dark alley. She's never seen this guy before, and that she's very seriously physically injured by rape, which actually holds true for a very tiny minority. In 90% of cases, the victim of rape knows the perpetrator, maybe a partner, an ex-partner, a relative, someone she's been on a date with. But what defence often do in court is try to distance the offence on trial from this image of real rape, which is very strong in a lot of people's minds. And the more successfully they can do that, and the more successfully they can discredit the complainant by drawing attention to her clothing, her drinking habits, her flirting, quite often it's thought that this has an effect on the jury. Certainly the defence think it has an effect on the jury, or they wouldn't do it.
Yeah, I think the whole bringing up the victim's sexual past as well is a really big thing in rape cases where, they're almost like shamed for being sexually active, whether it was with the accused or someone else, which I think is, I don't know if that's particularly a rape myth, but I think it's definitely a tactic used.
Oh yes, it certainly is, and indeed the law was changed here and in England and Wales to try to curtail the use of sexual history. It's the big thing about promiscuity, and again back to the patriarchal values that women are not supposed to be promiscuous, and if they are, then they're doing something wrong and they deserve to be raped. Certainly a rape myth. But despite the law being changed to kind of curb the use of sexual history in trial, it still gets in there. In fact, surveys in England and Wales have shown that it's been introduced in about 2/3 of rape trials, even though there are still ways and means to get it in evidentially. So it still gets in there, and we don't know, as I say, we don't know the effect it has on the jury, but certainly it's used.
Maeve, as working in the state attorney's office, did you ever see this brought up in cases? Did you find that it was a common thing, or is it more something that might be happening elsewhere, that it's maybe shown as being better not used over in Chicago?
Well, during my experience at the state's attorney's office, I did not actually see this get brought up in court. This doesn't mean that it doesn't happen, but during the trials that we had, this was not brought up. So I do not know. I bet it is a problem and has come up, but it depends on the jurisdiction that you are in.
Following the controversies of the Paddy Jackson case, Sir John Gillen set out an extensive list of recommendations on the report into the law and procedures in serious sexual offences in Northern Ireland, and he also includes measures to combat rape myths and stereotypes, such as more robust attitudes by judges to prevent improper cross-examination about previous sexual history.
Yes, Jade, more robust judicial rebuttal of some of the defence argument using rape myths was one of the recommendations. Others were stronger judicial directions to the jury, warning them against the dangers of believing rape myths, and also jury education, possibly showing the jury a short half-hour video before the trial to try to educate them about rape myths. Because as I said earlier, jury deliberation is really something we know very little about in this country. It's illegal to observe a jury deliberating or ask them any questions on how they reached their verdict. There are some very interesting studies with mock juries in England and Wales and other jurisdictions that have found that rape myths are influential in jury decision making, that they can prejudice juries against the complainant. So that might be one avenue. I know that in North America, the defence and the prosecution vet jurors for prejudice, and it's an interesting idea. It's one that Judge Gillen wasn't really in favour of, but I wonder what you think about that.
Yeah, I mean, the jury vettings in the States is very similar to Canada. I can't think of any particular cases that come to mind regarding jury vetting in Canada anyway, but something that kind of sticks out to me that's been pretty recent in the States is the Harvey Weinstein trial, and just how intense that jury vetting process was, as everyone probably knows, has been a 2-year-long process of getting him to case, of course, yeah. So, I mean, they had between 400 to 500 people vetted for the jury, and it was just a long process. It's very interesting to see how jurors are vetted and what is required of them, what's not required, and just, getting down to those last people, who can sit in on a trial like that and be impartial after being exposed to everything the past couple of years.
That's the problem, and it's very difficult to prove that leads to a fairer jury. The vetting system, of course, people are not going to openly declare prejudices, and in the case of rape myths, a lot of these biases are unconscious, so they may not even be aware that they have them.
Do you think a way to combat that would be for the court to just provide the expert witness instead of each side, and then for each side to just have the witness that they do? So the court would provide the medical examiner who would...
Well, they would be seen then to be on the prosecution side. I think that might be the Yeah, and the thing in a criminal trial is that all the power is seen to be with the state already, which is why the burden of proof is on the state and why the defence gets the chance to answer back, really. And so it's a difficult one.
Social media, obviously, when it comes to high-profile cases, plays a huge part. And relating that back to jury vetting, like as I said, it was a 2-year-long process getting the Harvey Weinstein to court. I'm not sure exactly how long the Patty Jackson one took to get to court, but there was no, obviously, jury vetting there. But I'm sure that the jury was seeing the reports, seeing media about it. So social media, I'm sure, plays a huge part in how juries, perhaps choose their decisions.
Well, they're not supposed to, and the judge warns them every day not to look at any media. But of course, this is the problem. We just don't know. And as you were saying, in a very high-profile case, this is one of the problems now: is the media coverage, and indeed the social media coverage. It's like everyone's got an opinion.
I know in the Republic of Ireland that the names of the accused are not made public unless they are convicted, and I think this would have made an enormous difference in the way in which the Belfast trial was reported upon, as much of the media and public interest related to the men's identities.
It's a good point, Jade, and many people would agree with you, but there are difficulties with not naming the defendants, and I think one of them in a jurisdiction as small as Northern Ireland is that the names would have got out anyway, and then we could have had the whole debate on social media and stripping out that layer of professional journalism, so we could have a lot of misinformation and disinformation coming from members of the public on social media. I think the names would have got out anyway in a small jurisdiction and in such a high profile trial. And I think there is a level of protection in having the reports from the professional media who are guided by professional codes of reporting.
I think it's important to contrast that to maybe Canadian and American reporting, because of course there are the professional journalists who report on it, but there's also there's an unlimited amount of online platforms like BuzzFeed, Vice, all these not professional platforms that talk about issues and trials and current cases going on that will be from an opinionated perspective, and that's more, I think, what people would be reading and have easier access to online. It's more what's going to be coming up. So it's really interesting, I think, to contrast that to here. You don't see that as much over here. You'll get more of a professional reporting.
It is, but it's part of the it's the problem of the modern world is that the internet and social media now is far outstripping the law, and it's causing some real problems to criminal trials. There is another side to that, in that social media and all these platforms allow counter narratives to emerge as well. In some ways, coming back to the rape myth problem, sure, social media and the internet can become a bit of an echo chamber, and they can magnify some of these rape myths. But on the other hand, there can be a counter narrative, and we saw the protests and the controversy over the Belfast Ulster Rugby trial. A lot of that emerged on social media as well. So it can be a force for good and bad.
Yeah, like I think had we not known about that down south, her underwear being held up in court, I think if there's no public outcry, how are we going to hold the courts accountable if everything's just hush hush and no one can be named and no public access? Then there's no accountability when it comes to the courts and the judges and the juries and the defendants.
Well, this is the principle of open justice. Justice has to be not only done but seen to be done. And if you take something like the Belfast trial, it's possible that the complainant would have endured a similar cross-examination because the jury would still have been there. She would still have gone through that ordeal of cross-examination and her underwear being produced in court, whether the defendants' names were publicised or not.
Yeah, I think it was in the Gillen report as well. One of the points made was that public access to trials involving serious sexual offences to be confined to close family members of the complainant and the defendant. So as someone who did actually sit in the trial, how would you feel about that if that did come into force?
Well, as a former journalist, I have mixed feelings about that. I can see in one way that, that could be, of course, the complainants in many of these cases are screened off from the public gallery. Mm-hmm. But sure, they still know that they're there. They still know that there's a public audience. I have mixed feelings about that. I'm not sure that it's necessarily the public in the court who are the problem. I think many of the people who comment, many of the keyboard warriors who comment on social media, have never come near the courtroom or indeed maybe read a lot of the professional reports on the trial. So it's a difficult one. But it may be something that would make the trial more comfortable for the complainant. But another thing that was being trialled in England is video cross-examination, which would take place away from the courtroom long before the trial and would mean that the complainant, in fact, didn't have to attend court if they didn't want to.
Yeah, because that kind of leads us into this idea of judicial rape, where a lot of sort of rape victims, suffer from the same trauma that they would have felt when the incident actually happened. And then they feel it again in court due to the rigorous cross-examination that they face. So I think perhaps, yes, like removing the public aspect of it perhaps might make it more bearable. But then again, this whole idea of open justice,
Sure. That could be. But as I say, having the cross-examination away from the court at an earlier stage where it's just the judge and the defence barrister, that could be another solution. Another solution that has been suggested by some people, not one that Judge Gillen was in favour of, is removing the jury altogether in rape cases because of this perceived problem of the effect of rape myths. As we said, we can't question the jury, we can't be privy to their deliberations, we don't know what effect exactly it has on them. But what do you all think about the idea of not having juries in sexual offences trials? This happens in some other parts of the world.
Well, I know in Iceland, I believe that they do it by a 3-judge panel. I find that idea very interesting. I'm not sure if I would want to be on the complainant side with just 3 judges. I think that having the power in the jury's hands thus far kind of makes it a little bit more of a human issue and less of just a really intense kind of scary law issue, which I feel like, yes, not having the jury, might take away some, you could assume it might take away some of the intimidation that a complainant might feel, but again, then you'd be facing 3 judges who have the fate in their 3 hands, who are just their job specifically is to look at the law. I'm not 6 sure. Yep, 6 hands. 6 hands. I'm not sure how I feel about that. I think it's a very interesting way and different way of approaching trials, but especially with even one judge, though. I don't think I would be in favor of having just one judge. I don't think putting this issue into the hands of one person, I think, is a lot of responsibility that I just don't think one person could adequately handle, especially with something as serious as...
A point to be brought up is that not all judges are saints, too. So you may have judges that have, prejudice on this topic, and it might not help. And having your peers review it, although there's issues with these rape myths being embedded within society and people being exposed and it being subconsciously there, I feel like it would be a better choice to have a jury as of right now until we can have judges that could be maybe somewhat regulated or educated on the topic beforehand.
Of course.
Yeah, is 10 people with rape myths any worse than 3 people with rape myth or that kind of subconscious bias? So I think you can't really remove you can't really remove rape myths just by removing certain type of people. I think that's going to penetrate into the court no matter what or who it is. Like even taking, like you said about not all judges being saints, the Brock Turner case, the judge, it was one judge who did give the final deliberation about his sentencing, and he gave him 6 months. You know, is that any better than what
6 months on good behavior?
On good behavior.
Which actually ended up being 3.
So, you know, I completely agree. I don't think I would be very much in favour of that.
Yeah, well, you know, you make a good point, and there are some judges in England who've made very seemingly rape myth sympathetic remarks in cases. I guess, yes, judges are supposed to be trained to be impartial, but a lot of these myths are subconscious. And then if we take away the jury, which is thought to be very important in the British justice system, a cornerstone of democracy, it doesn't solve the problem of the wider society and rape myth belief there. So I guess it's a bigger problem than just one for the courts.
For example, I actually recall a trial that Gloria Allred worked on where the survivor was a sex worker, and the judge actually called her all these degrading and awful names because of her occupation. And I think a good point to be brought up about having like the judge system is in the United States, we actually elect our judges. And even though they are supposed to be impartial, like what if you have somebody who has maybe a conservative mindset and you have a sex worker working in front of you? I don't think he's going to be very understanding or open-minding to the circumstances of the assault.
I think even just to prevent rape myths seeping into our courtrooms is to tackle it from society's perspective first. Rape myths are victim blaming attitudes. They're interwoven into our society. And I know that Sir John Gillen has recommended campaigns to help tackle these unconscious bias that are held in society.
Especially bringing it back to just at the education level, starting with schools. That not just we've been talking so much about judges and juries, but these juries and judges were raised in the same society and education system as all of us were, and if they weren't given the same introduction to the research that we've done ourselves, we can assume that not everyone's been educated on rape myths, and that's something that does need to be put into the education system from a young age so that these aren't internalized and grown and just expanded upon as we get older, the more that we are able to reflect on
or
these
even
issues.
Like passed on to generations. Like if you know from an early age about these and you're able to sort of dismantle them, by the time you're old and you have your own kids and you are a judge yourself, you're able to pass that on. And I think that's really important. So I think education at a young age so that men and women can identify this as early as possible so as not to internalize it is something that's really important. I agree.
There's a lot of backfire with the education thing by a certain population saying that teaching I don't want to teach my child about these violent crimes because of them being violent and it being a child. But there's ways that you can easily teach children by so where you wear your bathing suit is your private part. If somebody touches you where your bathing suit covers, you need to let an authority figure know. There's easy ways that you don't have to make them aware to the violent crime, that you can teach the younger population of these violent situations that do exist.
And then obviously adapting that education as you grow older for older young men and women to understand in a more deeper perspective what is right and what is wrong.
Yeah, I think we're going to end the podcast there with a very fun book recommendation, considering we were just talking about juries. It's a book called A Trial by Jury by D. Graham Burnett. It's really good, and it gives an insight into sort of jury deliberation and is it good to have juries or is it bad to have juries? And I think it'll be a really interesting read considering what we've just spoken about.
we'll just like to take this moment to thank Rosie Cowen for coming in and being our guest today.
Thank you.
She's been very insightful, provided us with some really good points and information that we all feel very fortunate to be able to reflect upon and bring back with us. And just to wrap up the episode, of course, we would just like to point out that we do have an Instagram account. This Instagram account is QUB Law Pod, and we would really encourage anybody listening to get involved, follow, like the posts, and we will definitely be posting about future episodes, questions that anyone might have. So please just make sure that you are following that, as well as our Twitter, which is also at QUB Law Pod. Thank you so much for listening, and we'll see you next time. This is Speaking Her Truth.